Hi, everyone. Harry here to talk about Donald Trump playing the same gambit before Judge Tanya Chutkan as with Judge Eileen Cannon. So recall that the current state of the indictment in Mar-a-Lago is that it has been dismissed based on a theory that has been widely criticized, even mocked, but is now up on appeal before the 11th Circuit. Well, Trump has now done the same thing before Judge Tanya Chutkan. He cannot hope to win there, but it is paving the way for an appeal in the D.C. Circuit and then potentially the more hospitable climate of the U.S. Supreme Court that has been good to him to date. The issue is whether Jack Smith's appointment is lawful. And although it is presented as if it's some basic constitutional separation of powers issue, it is not. Rather, an official of the status of Jack Smith, a so-called principal officer under the Constitution, either has to be confirmed by Congress or Congress has to provide for his or her appointment by law. And that is what's happened here, or at least every other court previously to Judge Cannon has determined. That is, there are statutes that Congress have passed that give the Attorney General authority to turn over the reins with oversight, as the Attorney General still has, of certain cases to Jack Smith. Jack Smith serves in this case in a manner analogous to a United States attorney. That's the position I held. It was confirmed by the Senate, which would make it a non-issue here. Here it's a simple appointment of the Attorney General. But there are several statutes that the government has advanced as saying, look, these provide authority for Merrick Garland to do exactly what he did do. And we have opinions that say exactly what Merrick Garland did here, and the wealth of opinion says precisely that. Judge Cannon reached out to inject ambiguity or uncertainty or opposing interpretations in the candidate statutes and to reach the conclusion that Congress had not provided the requisite power. She was acting based on a vein of opinion out there that's pretty thin and not very strong. But there was a Wall Street Journal editorial written by the conservative former Attorney General Judge Mukasey. And then in the immunity case, Justice Thomas writes a concurring opinion saying that the legality of his appointment raises questions. Doesn't even say, as Justice Thomas normally is unabashed about doing, that there would be a violation. Those are the tools that Cannon pieced together in order to reach her conclusion. And so the same is what's being now proffered to Judge Chutkan in this 30-page motion that Trump has just filed. About 10 pages of it is to justify the failure to have raised it earlier. So there's been a whole schedule in the case. Chutkan has insisted on proceeding methodically, and Trump has a number of arguments. Now it's a superseding indictment, or now we know separately because of the opinion by Judge Cannon and the immunity opinion. This proposed motion raises constitutional challenges that are important, and they go to the Constitution's structural separation of powers, citing cases where that was in fact true, but it's not true here. It really is just a statutory case. But all kinds of bromides about the fundamental importance of the separation of powers, and the assertion, therefore, that it doesn't matter that it wasn't timely when it's so important. A court of appeals could have brought it up, And the same thing with you, Judge Chutkan. Now, she finds legitimately that time has passed and he should have brought it before, and denies it on that basis. That's going to be the basis that will go up to the Court of Appeals and potentially the Supreme Court. In other words, the question presented will be, did she legitimately and lawfully oversee her own docket in the case? And that would be the basis for affirming without going into all this constitutional folderol. But you can imagine courts reaching out to try to look at this on the merits. And let me just cut to the chase of the sort of crystalline statement by the U.S. Supreme Court in the Nixon case that for most people does away with the whole argument without having to tease out the possible ambiguities, though other courts don't think they are ambiguous, to the particular statutory provisions. But okay, in Nixon, here's a statement from Nixon that seems to be completely controlling. Under the authority of Article 2, Congress has vested in the Attorney General the power to appoint subordinate officers to assist him in the discharge of his duties. That's this case to a T. And if it's a statement of law, Trump is out of luck. Canon will be reversed. And in essence, the whole appeal and the issue here rides somehow on trying to get around this huge brick wall of a Supreme Court statement. The argument that Cannon used and that Trump is using is, oh, that's just dicta. You've probably heard that term, and it is often real dispute whether something is dicta or not. But the idea is, was it part of the necessary rationale for the opinion and for winding up where they did? And if you go through everything in Nixon, it doesn't look at all like dicta. It looks very much like a conclusion that is part of a chain of reasoning that gets them to the final conclusion that the counsel there was properly appointed. And if they didn't have that and it fell away, there would be a hole in the reasoning. So it doesn't look like a very strong case for dicta, but it's one that Trump has to make, Cannon has to make, and we'll see what the 11th Circuit does first, probably, with Cannon's argument. Although what'll happen now in this case is the special counsel will answer in a week to 10 days, and then it will be teed up for argument. It will not be until after the election, and so we're in a whole different world where if Trump wins, he says just yesterday that he would fire Jack Smith in 2 seconds, and we know that the case would just go away. So it will matter if and only if Harris wins, but then it'll matter deeply because this will be, were he somehow to prevail at the Supreme Court level, and were 5 of them somehow to take Justice Thomas's half-hearted suggestion and make a full holding of it and disregard the Nixon dictum, then everything that Jack Smith has done, everything any special counsel has done, including the Hunter Biden case, all of it would be by the boards as unconstitutional. So for now, this is Trump trying his luck a second time, but with a judge who is not as handpicked and friendly. An aside on Judge Eileen Cannon, as she's apparently wound up on the short list for possible attorney general should Trump win the election. Judge Tanya Chutkan will not be, and this now goes in front of Chutkan. We'll see what the special counsel says, but I think there's a real possibility that Chutkan just denies the motion without even getting to the merits, saying it's late, you had the chance before, we've set a schedule that you violated, and that's the end of the story. And that will make the appellate route a lot steeper for Trump, although not completely impossible. Okay, so here we are in the same argument that won in Mar-a-Lago, but Mar-a-Lago, I think, has proven itself to be a unique setting in the Trump trials. And I look for a different result, maybe on procedural grounds even, so they don't even reach the issue before Chutkan. But overall, we're talking about whether a flat-out statement by the U.S. Supreme Court in the Nixon case can somehow be either construed as dicta and ignored, or just ignored, which the current U.S. Supreme Court certainly could do. And that, if this theory is to have any legs, is the issue that the courts will need to face. For now, it's just a motion, and we'll get the response, and the response will include probably a preliminary section saying you don't have to reach the merits here, even he hasn't played by the rules that you set. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.